Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with a few updates. It has been a busy 24 hours in the United States versus Robert Sylvester Kelly. And so you guys know that Judge Lennon Weber in the Northern District of Illinois gave the prosecution until the 24th to respond to Jennifer Bonjean's motion to dismiss. And of course, they waited till, after hours on the 24th to submit their response. And so we have that. And then we have a response from Jennifer Bonjean in the Eastern District of New York and a response from the prosecution in the Eastern District of New York. And if you guys recall, Judge Donnelly had two questions regarding the motion that Jennifer Bonjean filed in regards to the charges against Mr. Kelly that involved outdated statutes, concerning the transmission of STDs. And so both Jennifer Bonjean and the prosecution responded to that. And then the third thing is, several people had posted on my page about a month or two ago, and they were saying that the Minnesota charges against Mr. Kelly had been dropped. And I have been meaning to call Minnesota to ask them if that's true, because when I go on their website, they have a new website for holding court cases or court documents. And so I checked the old site and the new site, and I could not find any record of there ever being charges or an indictment against him in Minnesota. However, in my search, I did find that in February of last year, that the person who was the alleged victim in that Minnesota case filed a civil suit against him, where she's trying to get, I guess she figured if everybody else getting $4 million, she's going to get her $4 million also. And so I downloaded all those documents, but I never read them. And then today I found out, well, actually it was a post on social media where somebody was asking Jennifer Bonjean about representation in Minnesota. And she said that she was aware of the case and that they were she's not licensed to practice in Minnesota, but they were working on getting some attorneys on that case. And so I guess the person in that case, the Jane Doe, or however you want to refer to her in that case, has filed for a motion to default in that civil suit. And then somebody from, there are people in prison who are very well versed on the law. They have nothing but time on their hands. They study these law books. And I've actually read some motions that have been filed on Mr. Kelly to you guys that were written by another inmate, and then the whole situation in the Northern District of Illinois where they were trying to sue the warden at the MCC in Chicago. And so now if you send any communication to the MCC on behalf of Mr. Kelly addressing the warden, they're not even going to acknowledge it, because whoever this person was, they were firing off these legal documents against the warden. It was kind of hilarious to me. But somebody has responded to that civil lawsuit, basically saying that he has never been served any papers, didn't know anything about this lawsuit. And so in response, the lawyer for whoever this Jane Doe is has withdrawn their motion for a default judgment. And so I guess that would be worth keeping an eye on. But I'll go back and pull those documents up and read them to you that I had pulled from that website a few months ago. Then the other thing, this is just me and why I am so late with this video, because I have become so obsessed with this Amber Heard Johnny Depp case. Like, I am so behind on my work. Like, I have not done much of anything for myself because I am tuned into the channel, The Lead Attorney, watching his coverage of this Johnny Depp, Amber Heard case. And so today, there were two things that happened in the case, and one of them was a former TMZ reporter who wanted to testify that Amber Heard is the one that was sending them these videos. So I guess Amber Heard had accused Johnny Depp of leaking stories to the media. And so come to find out that the stories that were on TMZ, Amber Heard herself was calling TMZ to say, hey, you know, I'm going to be at the courthouse filing these documents, and then she actually posing for the pictures and whatnot. And so I thought that was hilarious. And then they had another specialist who came out and basically said that the images that Amber Heard has submitted that was showing her alleged bruises and stuff like that from altercations with Johnny Depp had actually been altered, that they were not original images. And so without the original images, he can't tell like if they had been photoshopped, but he could tell that the pictures at some point had been loaded into a photo editing program. And so I thought that was interesting, and that sort of relates to Mr. Kelly's case with these videos that are coming up in the Northern District of Illinois. You know, will Jennifer Bonjean have forensic specialists to be able to tell if these, you know, the videos have been doctored? The government claims that they've already had forensics people look at them, and they say that they are authentic and originals, but we will have to wait and see. And I'm thinking, we know they're not originals, because if the originals would be the videos that Mr. Kelly allegedly bought back from Lisa Van Allen and crew, or the ones that were retrieved by the investigator who was working with Daryl McDavid and the lawyer to get the videos back, right? So those would have to be the originals. And so if that's the case, where did the videos come from that Michael Avenatti had? So was Lisa Van Allen Michael Avenatti's client, and she gave him the original videos? So does that mean that the videos that she gave in exchange for the money were copies, that she kept the originals herself? So that is going to be very interesting to see how that turns out. And so we're going to go ahead and get started. We're going to start with the Northern District of Illinois response to the motion to dismiss. And remember, Jennifer Bonjean filed her motion wanting to dismiss these charges because she said that the statute that was in place at the time that these videos were allegedly made, and that these people are alleging that they were victimized by Mr. Kelly, that statute is no longer in effect, that there was a new statute written in 2003 and then another one in 2006. And so the government can't choose the 2003 and the 2006 regulations or laws or statutes that were in the books to prosecute these cases, that they have to go back to what was in place at the time that the alleged crimes took place, and that the statute of limitations has run out on that. Well, in the government's response, they are saying that that is incorrect, and that the reason it is incorrect is because at the time that the new statutes were written, the people in these cases had not exhausted the statutes that were in place at that time. So the 1994 statute that Jennifer Bonjean referenced said that until the people were 18 plus so many years. And so, for example, I think they had until their 25th birthday. And in the case of Rashona Landfair, she would have turned 25 in 2009. And so because the statute of limitations hadn't expired by her 25th birthday or the 25th birthday of some of the other people, then the 1994 rule wouldn't apply, and that they are able to use the statute that was in effect in 2003. So does that make sense to you guys? So they're saying that had they already turned 25 when the 2003 statute was written, then yes, Jennifer Bonjean would be correct. But because they hadn't reached their 25th birthday by that time, then it doesn't apply, and that she can't use that. So it'll be interesting to see what Jennifer Bonjean comes back with, because I think she'll get to respond before Judge Lennon Wepper gives his decision. And we pretty much know what his decision is going to be. So I am going to go ahead and read the motion to you guys, but I just want to explain to you what they're actually saying in this motion. So government's response to Defendant Kelly's motion to dismiss. Then they give an introduction about what she's trying to dismiss. And so it says, the United States of America, through its attorney, John R. Louch Jr., United States Attorney for the Northern District of Illinois, hereby responds to Defendant Robert Kelly's motion to dismiss counts 1 through 4 and 6 through 13 of the superseding indictment. Defendants Darrell McDavid and Milton Brown moved to adopt Kelly's motion as to counts 6 through 8 and count 6 respectively. Defendants argued that, except for count 5, all counts alleged in the superseding indictment are time barred. For the reasons set forth below, defendant's motion should be denied. So 1, applicable law. Between November 1991 and April 2003, the statute of limitations for offenses involving the sexual or physical abuse of someone under the age of 18 allows for the prosecution of such offenses at any time before the child reached the age of 25 years. See Title 18 United States Code Section 3509K, recodified as Section 3283. On April 30th, 2003, Section 3283 was amended. See Prosecutorial Remedies and Tools Against the Exploitation of Children Today, which is referred to as PROTECT Act of 2003, and then they give the publication numbers and all of that good stuff. And so the 2003 amendment extended the statute of limitations for offenses, including the abuse of a child, to the life of the child. The statute was again extended on January 5th, 2006, so that the limitations period would be the life of the child or within 10 years after the offense, whichever period was longer. See Violence Against Women and Department of Justice Reauthorization Act of 2005, and then they give you the publication number and the sections and all that good stuff. On July 27, 2006, Title 18 United States, try not to lose my place here, United States Code 3299 became effective when Congress enacted the Adam Walsh Child Protection and Safety Act of 2006, and then they give the publication information. That statute allows an indictment to be returned at any time without limitation for any felony in Chapter 109A, sex abuse crimes, or Chapter 110 child exploitation crimes, as well as other crimes involving minor victims. It is well settled that applying a procedural statute that effectively enlarges the limitations period, such as Title 18 United States Code Section 3283, And 3299 does not violate the ex post facto clause so long as the statute is passed before the given prosecution is barred. And then ex post facto is basically a term that's most typically used to refer to criminal statute that punishes actions retroactively, thereby criminalizing conduct that was legal when originally performed. So it is a rule in criminal justice that basically, if a crime is put on the books today, you can't go back and use that crime to convict somebody who may have did that act 20 years ago when it was not illegal to do that. So let me get back to where I was at. Let's see. And then they cite some cases. United States versus Gibson, that was heard in the 7th Circuit, 2007. And they were citing another case out of California from 2003. Then they cite another case that says, consistent with this general rule, multiple courts have held that the 2003 amendment to Section 3283 applies retroactively to extend the filing period for charges that were still viable at the time of the amendment. See United States versus Leo Surf Chief, which was a case heard in the 9th Circuit, 2006. As we have emphasized in this case, the statute of limitations had not yet run when the 2003 amendment took effect. So the amendment did not purport to resurrect an expired criminal charge. Accordingly, the indictment does not violate the ex post facto clause. And then that was from United States versus Jeffries from the 8th Circuit in 2005. In this case, Section 3509K extended the statute of limitations period before the prosecution was time barred, and Stogner does not affect extensions of unexpired statute of limitations. See also United States versus Maxwell, Southern District of New York in 2021. You guys know they are referring to Ghislaine Maxwell. Now that case just ended 2 months ago, and they're already using it as case study to build on other cases. And then in the Ghislaine Maxwell case, they were citing rulings from R. Kelly's case in her case to try to support the things that they were doing. So they are basically, as we have said all along, they are creating precedents. And this is why it is so important for people to be paying attention and to get out of their feelings. And regardless of how you feel about Mr. Kelly, understand that what they are doing to him is creating case law for future cases that may impact your family member. And so regardless of how you feel about him, you should care about how they are misusing the law and misusing their authority to convict this man and to create this case law that is going to be used against people in the future who are not well known, who are from your neighborhoods, and they're going to use that to circumvent, statutes of limitations and circumvent laws that weren't on the book at the time in order to find people guilty of crimes. So as set forth below, all charges included in the initial and superseding indictments returned on July 11th, 2019 and February 13th, 2020, respectively, were timely. The statute of limitations for each of the charges had not expired at the time of the 2003 amendment to Section 3283. As such, the amendment's extension of the limitations period to the life of the child, as well as all subsequent extensions, are lawfully applied to the charges and do not violate the ex post facto clause. 2. The superseding indictment complies with the statute of limitations. A. Exportation of minor 1 counts 1 through 4, and we know that minor 1 is Rishona Landfair. So the superseding indictment charges Kelly with enticing minor one to engage in explicit conduct for the purpose of producing 4 videos in violation of Title 18 United States Code Section 2251A. These videos were produced in or around the following years. Video 1, which is the subject of count 1, was produced in or around 1998 or 1999. So they have Rashona that's supposed to be their star witness, and they still don't have the exact date that these videos were allegedly made. Videos 2 and 3, which are the subjects of the which are subjects of counts 2 and 3, respectively, were produced between approximately September 26, 1998 and September 25, 1999. So wouldn't September 25th come before September 26th? But once again, you have a whole year span and you're not sure when the videos were produced, but you have the alleged person in the videos. So video 4, which is the subject of count 4, was produced in or around 1998. At the time the videos were produced in 1998 and 1999, minor one was between the ages of 14 and 16. So they don't even have the age right. The applicable statute of limitations was Section 3283, and at that time the statute allowed for prosecution of Section 2251A charges until minor one turned 25 years old. Minor one turned 25 years old in September 2009. Therefore, at the time that the statute of limitations was amended in 2003 to allow for prosecution of such charges at any point during the life of minor one, the original statute of limitations had not yet lapsed. As a result, counts 1 through 4 of the superseding indictment are timely. Kelly argues that the court should infer that Congress did not intend for Section 3283 to apply to conduct that predated the 2003 amendment because Congress ordered and rejected language that expressly prescribed retroactive effect. The Southern District of New York recently considered and rejected this argument in United States versus Maxwell, once again, Jocelyn Maxwell case, Southern District of New York, 2021. That court explained that the legislative history makes clear that the express retroactivity provision was removed because Congress intended to limit the PROTECT Act to its constitutional applications, including past conduct on which the statute of limitations had not yet expired. And then they cite the justice or the judge and their ruling, and it says that the fact that the 2003 amendment is silent on whether the new statute of limitations applied retroactively does not mean that the statute never can apply to previously committed acts. Leo Sure Chief, and then they cite the case or the document where this was at. To the contrary, Congress evinced a clear intent to extend rather than shorten the statute of limitations applicable to sexual abuse crimes, and as a result, prosecutions are timely so long as they present no ex post facto problem. Citing Jeffries again, holding in a case involving the extension of the statute of limitations for abuse offenses from 5 years to the child's 25th birthday, that the new statute could apply retroactively so long as the case was not time barred when the new statute was enacted, even though Congress failed to provide an explicit savings clause. Now let me go back up here because there was a note at the bottom of this page. So in the note, it says Kelly does not dispute the Section 2252A qualifies as an abuse offense subject to Section 3283. Abuse is not defined in Section 3283, but it is defined in the predecessor statute 3509A. Under that statute, abuse includes the employment, use, persuasion, inducement, enticement or coercion of a child to engage in or assist another person to engage in explicit conduct or the R word, molestation, prostitution, or other forms of exploitation of a child or incest with children. See United States versus NDIL, Fifth Circuit in 2015. The definitions contained within Section 3509 are the appropriate definitions to use in determining the application of the extended statute of limitations in Section 3283. So they're basically citing cases that they claim support what they are saying. So let's pick back up over here. It says, alternatively, Kelly argues that even if the application of 2003 amendment does not violate the ex post facto clause, the court could decline to apply the amendment to past conduct because it runs afoul of familiar considerations of fair notice, reasonable reliance, and settled expectations. Rule 189 at 8, citing Landgraf versus USI Film Products. And that was a case from 1994. Again, the case of Ghislaine Maxwell is instructive. As the court explained, the PROTECT Act did not deprive Maxwell of any vested rights. Maxwell contends that it is unfair to allow the government to prosecute her now for conduct that occurred more than 20 years ago. But there is no dispute that Congress has the power to set a lengthy limitations period or no limitations period at all. It has done so here, judging that the difficulty of prosecuting these offenses and the harm they work on children outweighs a defendant's interest in repose. Maxwell's fairness argument is a gripe with Congress's policy judgment, not an impermissibly retroactive application of the statute. The court concludes that Section 3283 allows her prosecution now. And once again, that was from the Maxwell case. It says this court should reach the same conclusion and deny Kelly's motion to dismiss counts 1 through 4. So what this tells me is that it's really up to the judge whether or not the judge wants to see it as being retroactive or not. Because I guarantee you, if Bonjean is able to respond to their response, she's going to pull recent cases where a judge ruled otherwise. So it basically comes down to who the judge is and how the judge feels on that particular day or about that particular person as to how they will rule as far as dismissing the charges. So then they go into B, enticement of minors to engage in unlawful conduct, counts 9 through 13. So Kelly is also charged with 5 counts of enticing minors to engage in unlawful conduct in violation of Title 18 United States Code Section 2422B. For the same reasons set forth above, these charges are timely. Counts 9 through 13 allege that between 1996 and 2001, Kelly enticed 5 people to engage in activity for which any person can be charged with a criminal offense. The relevant offense period and age of each person is set forth below. Now, y'all pay attention to this because some of y'all have reached out and you were trying to help me figure out who these people are in this case. And so we get a little bit more information about them in these descriptions. And so I know a couple of people were talking about Tiffany Hawkins and Javante Cunningham had talked about these 2 people that were possibly in this case, or they had talked about 2 people, and people are surmising that they might be 2 of the people in the case, and somebody named Khadijah and somebody named Ebony. And my only thing about those 2 suggestions was that based on the information that was provided, if they are 2 of the people in this case, they were much younger than Tiffany and Javante. So what does that say about them if they were hanging out with people that were like 5 to 7 or 8 years younger than them? Because in 1996, Tiffany Hawkins would have been 20, I believe. So that would have made one of these girls like 15 and the other one like 12 or 13. So why were they, if they had gone through these experiences and felt remorse about those experiences, then why wouldn't they be telling these other young women like, oh, don't do that, don't go that way? But unless it is true that basically this was the hustle and that they were telling these girls, oh yeah, if you want to make a quick million or a quick $200,000, go to Susan Loggins, file this lawsuit and say that this happened. Like, you're not going to have to prove anything. And then here we are years later, you know, with them being in this case. So if you know who this Khadijah is and this Tiff and this Ebony chick is, and you know when their birthdays are, then you can come back and let me know for sure if these are them or not, because they give us a little more information here. So it says, count 9 charges that between 1997 and September 2001, he enticed minor 1 to engage in activity that constituted aggravated criminal abuse in violation of 720 Illinois Code, 5/12-16D. At the time of the offense, minor 1 was between 13 and 17 years old. As stated above, minor 1 turned 25 years old in September 2009, and we know that minor 1 is Rishona Landfair. So, count 10 charges that during the summer of 1996, Kelly enticed minor 3 to engage in activity that constituted aggravated criminal abuse in violation, and then they give the same code. At the time of the offense, minor 3 was around 15. Minor 3 turned 25 in August of 2005. You got that? So minor 3 would have been 25 in August of 2005. So count 11 charges that between 1999 and 2000, Kelly enticed minor 4 to engage in activity that constituted the exploitation of a person in violation of 2251A. And it says at the time of the offense, minor 4 was between 16 and 17. Minor 4 turned 25 years old in August 2007. Count 12 charges that between 1997 and 2001, Kelly enticed minor 5 to engage in activity that constituted aggravated criminal abuse in violation of 720 Illinois Codes 5/12-16D. At the time of the offense, minor 5 was between 13 and 17. Minor 5 turned 25 years old in October of 2009. Count 13 charges that between 1997 and 2000, Kelly enticed minor 6 to engage in activity that constituted aggravated criminal abuse in violation of 720 Illinois Codes 5/12-16D. At the time of the offense, minor 6 was between 13 and 17. Minor 6 turned 25 years old in December of 2008. So at the time of the offense, and you know what, and this really doesn't make any sense because I swear on the indictment, minor 5, they say it was between 13 and 15, and that minor 6 was between, 15 and 17, I think it was. So how are they going to put them in the same age bracket? So they're doing some fuzzy math over here. So anyway, and if you know when the person's birthday is and when they turn 25, I'm still trying to understand why they can't narrow down when these alleged acts happened. And then how does he prepare a defense when you're giving such a wide range of dates? Like, how do you go back and check your calendar or check what you were doing if you don't know the dates? And that's the same thing that's happening in the Bill Cosby case, because the lady in the Bill Cosby case for that trial that's about to start June 1st is actually a civil suit, not a criminal case. But she kept saying that, oh, this happened in August of 1974. So they've gone through the trouble to subpoena the records of the Playboy Mansion to see if Mr. Cosby was there during the time she said they were there, and whether or not she was listed as one of the guests that he brought into the mansion, because they had to know who was in the building at all times. So they go through the trouble to pull all this information, and then they come back and say, okay, well, we have no record of you being at the Playboy Mansion in August in 1974. And then now the lady is saying, oh, you know what? It wasn't in 1974. It was 1975. So 2 weeks before the trial, suddenly you remember it wasn't 1974. It was the following year. So now they don't have time to go back and pull all these records from the Playboy Mansion to see if she was there in 1975. And then if they prove that she wasn't, is she going to change the date again and say, oh, well, it was 1973 or it was 1976? And that's sort of the same thing here. How does he launch a defense when he can't go back and check his records, check his schedule to see where he was, to possibly pull witnesses who might have been with him at a party on a certain day or at a certain time, or he might have been out of the country or somewhere, when you can't narrow down the dates of when this stuff actually happened? It's just crazy to me. So it goes on to say, at the time of the offense conduct charged in these counts, the applicable statute of limitations was section 3283, and at the time, the statute allowed for prosecution of section 2242B offenses until the people turned 25 years old. As set forth above, none of the minors included in the indictment had reached the age of 25 at the time that the statute of limitations was amended in 2003 to extend the statute of limitations to the life of the person. As a result, counts 9 through 13 of the superseding indictments are timely. C. Receipt of CP, counts 6 through 8. The superseding indictment charges defendant Kelly, McDavid, and Brown with conspiring to receive CP in violation of Title 18 United States Code, Section 2252A2 and B1. Count 6. Specifically, Kelly, David, and Brown are charged with conspiring to receive videos 2, 3, and 4, which, as discussed above, depict the exploitation of minor 1, who is Rashona Landfair, as alleged in the superseding indictment. The conspiracy began in and around August 2001 and continued until in or around April 2007. The superseding indictment further alleges that Kelly and David received CP, namely videos 2 and 3 in August 2001, count 7, as well as video 4 in April 2007, count 8, in violation of section 2252A, capital A, lowercase a2. And then let me go back up here because they have a note, and the note says defendant does not dispute that section 2242B qualifies as abuse offense subject to section 3283. The statute requires proof that the defendant persuaded, induced, enticed, or coerced a person to engage in unlawful conduct. That statute mirrors the language of section 3509A's definition of abuse. And then let's stop here and talk about these videos, because it came out, there's this, I've talked about this Twitter page to you guys before called Michael Avenatti's Toilet. Well, evidently Michael Avenatti has been transported to the MDC in Brooklyn, which is where Mr. Kelly is being housed. And I just think that's so poetic because, and I posted this on Twitter. You guys remember that saying? And then after I posted it, might have been in a song. But anyway, it goes, if you dig one ditch, you better dig two, because the trap you set just might be for you. So I just think it's just so ironic that convicted Michael Avenatti is now being housed in the same jail that Mr. Kelly is being housed in, when he worked so hard to bring this man down, which brought me to another thought, which was going back to the Amber Heard case. Oops. going back to the Amber Heard case where they brought in this specialist today, to say that those photos were not the originals, that they could have been doctored. So do they have the original videos, or are these copies of the original videos? Because if they got the videos back in 2001 and 2007, then what are the videos that Michael Avenatti had? Evidently, those are copies, right? And what happened to the videos? So we know Kim Fox has the videos from Michael Avenatti. So are those the videos that she gave to the Northern District of Illinois, or does the Northern District of Illinois have some other videos which are the same videos? And so we know if they're the same videos, they have to be copies, right? And they're saying that the videos have been authenticated, but Mr. Kelly needs to bring in his own forensics people to come back and say, no, these are copies, these are not originals, and these could have been altered and doctored. So that is going to be very interesting to see how that turns out. But anyway, we shall proceed. I'm almost done with this document. It says all three of these counts are violations under Chapter 110 of the United States Code, which includes both the substantive offense of receiving CP as well as all attempts and conspiracies to receive CP. See Title 18 United States Code, Section 2252A-B-1. Whoever violates or attempts or conspires to violate, and then it has paragraph ... 2 ... of subsection A ... So they're not telling us what the whole thing says. So there is no statute of limitations for charges under Chapter 110 pursuant to Title 18 United States Code Section 3299, which was enacted in July 2006. An indictment may be found or an information instituted at any time without limitation for any felony under chapter, and it has ... for any chapter under chapter, for any felony under chapter ... 110, except for sections 2257 and 2257A ... which means that they're just picking and choosing parts of the statement to put in this motion. They're not giving us what the whole thing says. So section 3299 applies to count 6 through 8 because the statute of limitations had not expired as of the statute's enactment in July 2006. Two of the counts, counts 6 and 8, allege criminal conduct that did not conclude until after section 3299 was enacted. Count 6 alleges that from August 2001 and continuing until April 2007, which is after July 2006 when this law was enacted, Kelly, McDavid, and Brown conspired to receive CP in violation of Title 18 United States Code, Section 2252AA2 and B1. Likewise, Count 8 alleges that Kelly and McDavid received CP in 2007, again after Section 3299's enactment. In other words, as of July 2006, the statute of limitations for these counts had not expired, and therefore Section 3299 applies. As to count 7, the superseding indictment alleges that in August 2001, Kelly and McDavid received videos 2 and 3, which depicted the exploitation of minor 1 prior to Section 3299's enactment. The statute of limitations for this count was either the life of the child pursuant to Section 3283 or the default 5-year statute of limitations set forth in Title 18 United States Code Section 3282A. Either way, the government's prosecution of Count 7 is timely. As set forth above, a procedural statute such as Section 3299 does not violate the ex post facto clause so long as the statute is passed before the given prosecution is barred. And then they cite a case, and then the 5-year statute of limitations for Count 7 did not expire until August 2006, which is after Section 3299 was enacted in July 2006. Likewise, if the statute of limitations was the life of the person or until the person victim turned 25, minor 1 did not turn 25 years old until 2009. In short, the offense conduct charged in Count 6 through 8 could have been timely prosecuted at the time that Section 3299 eliminated the statute of limitations for Chapter 110 offenses. As a result, Section 3299 is lawfully applied to these counts, and the government's prosecution is timely. And then at the bottom, there's a note: there is case law to support the argument that the 2003 amendment of Section 3283 applies to CP offenses and thereby extended the statute of limitations for count 7 to the life of minor 1, and then they quote some cases. However, it is unnecessary to undertake this analysis for the purpose of defendant's motion, as count 7 is timely, even if the statute of limitations was 5 years at the time of the offense conduct in August 2001. 3. Conclusion. For all of the reasons set forth, the court should deny defendant's motion to dismiss counts 1 through 4 and 6 through 13 of the superseding indictment. Whew, alrighty then. So once again, just to sum all of that up, basically what they're saying is, in the original rules or statutes that they are charging him under, that they could have, the rules allow the cases to be prosecuted up until the people were 25 years old. And at the time that the 2003 amendment came out and the 2006 amendment came out, none of the people in the indictment had turned 25 years old yet. Therefore, when the new rules came out, because they were still under the limitations for the cases to be prosecuted, that gives them the right to then ignore the statute that was in place at the time the offenses happened and move to the statutes that were in place based on the limitations, the statute of limitations in place. And so since they hadn't reached those statutes of limitations, they could go with the law that says that there are no statutes of limitations, that they can prosecute these cases whenever, which I think is crazy as hell, because you could be 60 years old suffering from dementia, and somebody from 50 years ago can come and say you did something to them, and they are allowed to prosecute you for that, even though you don't remember what happened. There's no proof of what happened. There's no evidence or anything like that. They can still come and prosecute you for those crimes. And to me, that is just crazy. So I'm going to go ahead and leave this here. Go ahead and leave your comments below. Rate the video and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.